Okay, good morning. Make sure we can hear you all, Mr. Dietz, Mr. Rosenwald, Mr. Mason.
Yes, sir.
All hear me?
Good morning, Your Honors.
Good morning, Your Honor. This is Rob Rosenwald.
Okay,
This is Stephen Mason representing the Appellees.
okay. I understand that Mr. Rosenwald and Mr. Dietz are going to be splitting your time.
Correct, Your Honor. I am doing the first 7 minutes and reserving 3 minutes for rebuttal, and Mr. Rosenwald is doing 10 minutes.
Okay. All right, I'm going to go ahead and introduce the other members of the panel. I have Judge Richard Orfinger and Judge Brian Lambert with us today. These oral arguments are being streamed so that the public can view them while the arguments are going on. We'll go ahead then and take up the case, and Mr. Dietz, you can go first. You may proceed.
Thank you, Your Honor. Good morning, Mr. Chief Justice, Your Honors, and may it please the court. My name is Matthew Dietz, and I represent Anita Giannis and Brittany Smith in this action. And I'm going to start the argument, and I'm going to discuss the issues of preemption and the facts. And Mr. Rosenwald, who is the city attorney from the city of Miami Beach, he represents the Amici in this action. Your Honors, this case is a simple case of discrimination where Ms. Smith and Ms. Giannis went to a gentleman's club in Orange County and was told that they could not enter because they were unaccompanied by men. And the reason was because women unaccompanied by men are there to cause problems or are there to be prostitutes. They were not permitted in, and they sued under the Orange County Code of Ordinances. The circuit court dismissed the case based upon the fact that the circuit court believed that the Florida Civil Rights Act was a comprehensive plan from the state that preempted local human rights ordinances. This is contrary to over 35 years of law in this state. This started with the Attorney General's opinion in 1984, which found that there was no preemption between local ordinances and the Florida Civil Rights Act. And then there were a group of 3 cases decided by our Supreme Court, which held similarly. The first one was Broward County versus La Rosa, which was the race discrimination provision of the Broward County ordinances. In that case, Your Honors, the court found that the ordinance survived, but there had to be a claim in circuit court because there could not be a claim administratively for non-economic or punitive damages due to the Florida Constitution. Similarly, that very same year in Metro-Dade County Fair Housing and Employment Appeals Board versus Sunrise Village Mobile Park, the Supreme Court again held, and this was the housing ordinance for Miami-Dade, that they could have an age ordinance, that counties had that power to do that. And in that, the court held the same thing, that in order for you to have a civil cause of action for non-economic damages, and non-economic damages are the gist of a discrimination action, in many of these cases, you have to have that action in a judicial form. The third case in this group of 3 from the Supreme Court was Laborers International Union of North America, Local 478 versus Burroughs, which was in the Florida Supreme Court in 1989. And that was more similar to this case. In that case, it involved the employment discrimination provisions of the local ordinance. And the Miami-Dade local ordinance had a lower number of people to meet the threshold of the act. Under the Miami-Dade County ordinance, you need 5 employees to meet the threshold. Under the Florida Civil Rights Act, you need 15 employees to meet the threshold, as well as the similar EEOC Title VII, you need 15 employees. The court held that there was no conflict between the Miami-Dade County Code and the Florida Civil Rights Act. Because
Mr. Dees, let me ask you this. Do you believe there's a conflict to the extent that the state statute provides for an administrative remedy as a condition prior to filing suit, and the Orange County ordinance does not? It permits a party to go immediately to a lawsuit and not go through any administrative action first.
No, I don't believe there's a conflict at all. In fact, the administrative remedy provision is a lot less severe of a change in the statute, a lot less material change in the statute than the Supreme Court's decision in Laborers International. But I think the important, and also, Your Honor, the Northern District of Florida in Randolph versus Family Network of Disabilities of Florida, which is a 2012 decision, decided this exact issue, whether or not the administrative procedures are a bar to a conflict, and the Northern District found it didn't. But one of the facts that is important in this is what the court's decision was in the Sarasota Fair Elections case, in which the Supreme Court, this was in the Sarasota for Fair Elections case, and that was a preemption case. And in that case, the court found that the election code did not preempt the Sarasota's local ordinances, and it went through the local ordinances in specificity. And it found several areas that the law gave the board discretion to pass ordinances. In this statutory provision of the Florida Civil Rights Act, it does the same thing. It provides a carve out for administrative procedures. And that is specifically in chapter 760.07. In 760.07, it states, if the statute prohibiting unlawful discrimination provides an administrative remedy, the action for equitable relief and damages provided for in the section may be limited only after the plaintiff has exhausted his or her administrative remedies. So in doing the statute and drafting the statute, the drafters specifically limited out only those cases, only those matters that are administrative that do not have any other remedy must go through the administrative remedies in chapter 760. They had the opportunity to say all statutes can do that, and the legislature has not been shy in doing so. In this case, they specifically, in the text of the statute, limited it. I'm going to, my 7 minutes is up, and I'm going to turn the tables over to my colleague, Mr. Rosenwald.
All right, Mr. Dietz, when you do get up for rebuttal, I do know the motions panel did not allow this appeal to go through, but the merits panel can make a separate decision. And anyway, give thought to whether this is a final appealable order or non-final, non-appealable order, and address that on the rebuttal when you start, okay?
Yes, Your Honor, thank you.
All right, Mr. Rosenwald.
Good morning, Your Honors. My name is Rob Rosenwald, and I am First Assistant City Attorney for the City of Miami Beach. I represent Orange County, Miami Beach, and 21 other local governments that have appeared as amici today before you to argue in favor of the appellants and the validity of the Orange County ordinance. And thank you for allowing us to briefly argue before you in this important constitutional case. In my short time, I hope to cover, if I have time, 3 main points. First, because Orange County was not made a party to the action in the trial court below, the trial court never had the issue of the validity of the Orange County ordinance properly before it, and was not empowered to invalidate that ordinance and to make the decision that it did. The second, that
you concede, though, it complied with the rules of civil procedure.
I'm sorry, Your Honor.
You concede they complied with the rules of civil procedure. Rachel's did.
Well, the rules of civil procedure that they complied with that one business day before the hearing on the motion. It was filed 6 months. The motion to dismiss was filed 6 months earlier. The hearing was held 6 months later. One business day with a weekend in between, they filed the notice with the state attorney as required by Rule 1.071. And then the next day was the hearing. But however, the statute is an additional requirement. The rule does not take account of what happens when you're trying to invalidate a local ordinance. And the statute 86.091 does indeed. And it says, in any proceeding concerning the validity of a county or municipal charter, ordinance, or franchise, such county or municipality shall be made a party and shall be entitled to be heard.
Doesn't that apply only in the declaratory relief actions?
I don't think it does, Your Honor. I think that the statute's language is clear and says, in any proceeding concerning the validity of a county or municipal ordinance, the municipality shall be made a party. Your own.
Isn't the ordinance that precedes that the one that you just read to me?
When declaratory relief is sought, all persons may be made parties who have a claim or interest which would be affected by the declaration. No declaration shall prejudice the rights of persons not party to the proceedings. And in effect, what the defendant here sought to do was to seek a declaration that in defense that the Orange County ordinance was invalid without naming Orange County and allowing it to be heard. And this principle has been upheld in Seminole Entertainment, Inc., which is a 5th DCA from 2004, which says when a aggrieved party asserts a constitutional challenge, an original declaratory judgment or injunction action in circuit court is the proper vehicle. Bohenton v. CESE, which was a circuit court action that's obviously only persuasive authority, but one we're asking you to adopt, said if defendants wish to challenge the constitutionality of the Leon County HRO, they must file a declaratory judgment claim under section 86091 and name Leon County as a party. I can tell you that both the plaintiff and the defendant knew this requirement. At the hearing on the motion to dismiss below, Mr. Mason was speaking, and he said, I have electronic mail correspondence I'll provide the court. I'm familiar with the county attorneys. I'm familiar with their code. I've contacted them telephonically. I've contacted them electronically as early as last summer and told them about the case. And they got back to me and said, if we're a defendant, then we'll do what defendants are required to do and defend. Other than that, Mr. Mason, you can do what you think is best for your client. That's at the hearing transcript, page 27, lines 16 through 18. And also then Mr. Mason went on to say that he decided not to do that. He decided not to make them a defendant. At the transcript at page 13, lines 12 through 16, he said, quote, I've done everything I can to get Orange County lawyers in here other than, trying to force them through some kind of intervention or naming them as a party as they were required. Quote, I've called them on the phone. I've sent them emails. I've sent them letters. And as I said, the official notice that he gave to the state attorney, which never necessarily made it to Orange County at all, was given literally one business day before the hearing after the motion was pending for 6 months. And I'll tell you, this case is a perfect example of why this rule makes sense. If Orange County had been named as a party and had come in to defend on the issues of constitutionality and preemption, areas that local governments have expertise. The county attorney's office, I'm certain, has argued many preemption cases, in many cases defending the constitutionality of their ordinances, and the trial court would have been given a cogent and a response to the challenge that would have neatly laid out all 5 of the decisions that Mr. Dietz asserted for you that held that local HROs are not preempted and do not conflict with the Florida Civil Rights Act, versus the 0 cases that have ever held, ever in the history of the state, that a human rights ordinance was preempted or conflicted with the Florida Civil Rights Act or its predecessor, which was essentially the same, including its administrative review process.
Does the Florida Civil Rights Act cap punitive damages at 100,000?
It does, Your Honor, yes.
What about the HROs that we're discussing here? Do they have any similar cap on punitive damages?
Well, they don't have a cap on punitive damages, but they have lesser damages in other respects than the Florida Civil Rights Act. For example, the Orange County HRO and the Leon County HRO, which is almost identical and is the subject of the Bohanton case, neither of those allow for pain and suffering and humiliation and unliquidated damages of that sort. So there's a very large limitation that makes the local ordinance in many cases much less generous to a plaintiff than the Florida Civil Rights Act, because as you know, pain and suffering is easier to prove. All you have to do is testify about it, and punitive damages is much harder. So in answer to your question, yes, the local ordinance does not limit punitive damages and the FCRA does, but it limits damages in other ways that make it less generous than the Florida Civil Rights Act.
Well, if the Florida Civil Rights Act says you can get no punitive damages, and the Orange County ordinance says you can get punitive damages as determined by whoever, jury or judge, wouldn't that be directly in conflict and that become problematic with the Orange County ordinance in that regard?
Absolutely not, Your Honor.
Really?
The Florida Civil Rights Act, the Florida Civil Rights Act says you need to follow our procedure if you want to proceed under state law to collect damages. And if you proceed under state law, these are the damages you can get. The Title VII says if you want to proceed under Title VII, you need to follow our procedure, and these are the damages you can get, which incidentally are different and more in some cases and less in others than the Florida Civil Rights Act. And the local ordinance similarly gives more in some instances, less in others. But the key argument here is that the Florida legislature has never indicated that it intended to be the sole mechanism by which the Florida Civil Rights Act to be the sole mechanism by which you can collect damages. And that is what the case law requires that we've cited in our brief, that the Florida legislature would need to say, and has never said. And by the way, we know that they know very well how to say, we want to preempt this to the state, or we want our procedure to be the only procedure that you can follow in order to collect damages under any ordinance or statute. And they have not done that. And
Mr.
so,
Rosenwald, you're well into your rebuttal time.
I'll leave then I'll cede my time and let Mr. Dietz have his time.
Thank you. Mr. Mason.
Argument. I like my argument to track.
Mr. Mason, I can barely hear you.
Judge, can you hear me now?
Not well.
Oh, goodness. Judge, can you hear me at all?
Not very well.
I can hear you. I don't know.
I can hear you.
All right,
But
go
the-
ahead then.
My hearing's better than Judge Evander's.
Thank you. This is the first time I've ever done a digital presentation before either a trial judge or obviously the appellate court. But I can tell you what I want to talk about is I want to talk about the trial judge. I want to talk about the trial judge's mindset. And then I want to talk a little bit about conflict, Stacey McLean, and I want to move through preemption and their Chapter 62 arguments and these arguments regarding boroughs and these early 1980 cases, none of which address preemption. I've gotten the briefs from the Florida archives, and they're flat out wrong.
You agree that there's no express preemption here, correct?
100%, I agree with that. This is the case, and I can't read your minds. I'm not part of the discussion. This is the case that's going to decide whether or not there's implied preemption. This is the case that's going to decide if there's conflict, and if so, what the basis for conflict, or whether or not both of those doctrines are violated. And that's why this case is a hot potato. And that's why the particular trial judge here took it under advisement for 3 months. He could have easily, because judges are trained, they're trained by constraint. He could have easily said, I'm going to go with the micro issue, and I'm going to attempt to invalidate this ordinance on conflict, either on punitive damages or the mandate of 76011, and he could have started and stopped there. But he did not. He recognized how significant this issue is, and therefore he invalidated it on implied preemption, and he invalidated on an alternative argument of conflict. I mean,
let me ask you this, Mr. Mason. If we were to agree with your argument on the merits here, and I'm not saying we are, but if we were, would the county be bound by our determination that the ordinance is invalid?
Not only would the county be bound, every village, municipality, and the counties across the state of Florida, if you invalidate it on either ground, conflict or preemption or both, they are all stricken. Do
you see a problem with us addressing the merits and binding the county to that legal determination when they have never been made a party to this proceeding?
No, and the reason is the case they cite, the Castleberry case, that was similar. That was another Rachel's case that I litigated in front of the 5th District Court of Appeal, I don't know, roughly 20 years ago. That was a declaratory judgment case. There is no decision, unless this is going to be the first one, that says that if you are hauled in as a defendant in either a criminal case or a civil case, you have to file a separate lawsuit, or you got to somehow interplead someone who drafted the legislation by which you're charged. I mean, we're civil.
Wasn't your motion to dismiss in part based on a request to declare the ordinance invalid?
I'm asking to dismiss it because you don't have a cause of action if your cause of action is predicated upon something that's constitutionally infirm. So could we get
right. That's my point. You were asking the judge to declare that the county ordinance was unconstitutional because it was either inconsistent or was preempted by a state statute.
Absolutely. And let me just, oh, I'm sorry.
So why would that not fall within the ambit of 86.091 if you were in essence seeking that declaration?
3 reasons. One is Chapter 86 is bound and based upon its title, the ambit of what you're requesting there. And Chapter 86 is the declaratory judgment statute. And if you're filing a declaratory judgment, you bring in the party defendant to invalidate the state statute, the city provision, or the county provision. If we're going to take the leap, and it would be a leap, that procedurally that statute trumps the rules of civil procedure, and that the Florida legislature, bless their heart, somehow they're now in charge of procedure, and that when a defendant comes in and seeks to defend themselves, claiming there is no cause of action, that you have to file an independent lawsuit or interplead, then essentially we're crafting a new rule of procedure when no appellate court in the state of Florida has done that. But
would it be a leap? Would it be a leap for us to find that a county's ordinance can be declared unconstitutional on its face without them ever being named a party? Would that be a leap? Are you aware of any case law where an appellate court has done that?
It is done maybe not every day of the week, but in criminal cases. Consider a criminal case, how often, or even civil cases. If we went back and you said to us, Mr. Mason, and I'll let you file a supplemental 5-page brief, give me some cases in a civil context or a criminal context or both, where ordinances were invalidated on a motion to dismiss, and whether or not there was an independent lawsuit or an interpleader, I feel fairly confident that I could come up with a laundry list that says that, and that
in a criminal case, would you agree the state's already a party? They're there, they can defend a state statute.
They can defend a state statute. But for instance, if you look at the Thomas case, think about Thomas. The Thomas case, which is a conflict case cited in our brief, as a case that I was involved with, the underlying issue in that case was a city ordinance. and it was the state of Florida, and we never interpled or brought the city of Orlando in, and the Florida Supreme Court invalidated the ordinance, finding that it was in conflict, just like this case where they're saying, oh, we've changed the remedies and we've changed the punitive damages where the sky's the limit, where these small business owners can be levered for all sorts of funding based upon alleged discrimination. And they found that when you change penalties, you rise them above whatever the cap is, that's invalid. I mean, that's Thomas on all fours. But even if I'm 100% wrong, which I don't believe or concede that I am, but let's assume that I am wrong. If I'm wrong, the court never makes litigants engage in acts of futility. I mean, this particular judge, Judge Karsten, if we sent this case back to him and said, you know what, Orange County gets to file a brief. I recognize they filed briefs in Daytona Beach. I recognize they appeared at the oral argument via their amicus counsel, et cetera. But they're going to file a brief or a paper in front of me, and I'm going to rehear the case, and I'm going to issue another order. We're going to be right back here. I mean, just as a matter of constraint and resources and time and just acts of futility, I can't imagine the court doing that and allowing that to occur. But I'm not an appellate judge. I'm not an Article 5 judge. I'm just a working lawyer. But I can tell you that on both conflict and preemption, this case has great consequences. In terms of preemption, they've cited a 1984 opinion from Jim Smith, who used to be the Florida Attorney General. If you look at that opinion, which is roughly 35, 40 years past, in that opinion, the Attorney General does not make reference to certain provisions in Chapter 760 regarding the discretionary, permissive, non-mandatory powers of local human rights commissions. All he does is make reference, I believe, to 760.06 that talks about promoting cooperation with local commissions. And the reason he didn't make reference to 760.11 subsection 2 that talks about these local commissions that the lawyer from Miami Beach is well aware of, that those commissions are not empowered to adjudicate these matters, is because the Florida legislature amended 760.11 and said those commissions are discretionary. And if there's a referral, a discretionary referral from Tallahassee, from the Florida Human Rights Commission, it is purely discretionary. They can investigate it at the will of Tallahassee. They can investigate it at the will of the Florida legislature. It'll be given great weight, but they do not have the power to adjudicate it. They cite two cases on conflict. One is a case called De La Rosa, and in their brief, and I'm not accusing them of anything improper. I'm just saying that lawyers are clever people. I'm a clever lawyer, and we have a tendency to omit pertinent things in our arguments. They quote or give a parenthetical in their brief, and they quote from De La Rosa, quote, local governments have the power to adopt appropriate legislation to further the elimination of invidious discrimination. That sounds quite powerful, but when you actually go back and pull the opinion, what it says is, both parties agree that local governments have the power. That's not even obiter dictum. That's just a statement of procedural fact of neither party litigated preemption. If you look at the Burroughs case, preemption wasn't litigated in Burroughs. We're talking about that case originated in 1980, 1981. I spent a large amount of time. If I go back in time, I do even a better job of tracing the history of the 1969 Florida Civil Rights Act to the present day. And the reason I did that was in 1980 and 1981, most of these, a great many of these provisions in the statute and in Chapter 760 did not exist. But I went even further. I went back and I contacted the Florida Supreme Court. They did not have the briefs. I went back to the archives, the state archives, and I got all the briefs in these cases, or specifically I got the briefs in Burroughs. Preemption was not an issue. And so when they come up on a reply, they should respond and say, well, do courts adjudicate issues that are not raised and brought before them? If the Florida Supreme Court had ever litigated or adjudicated implied preemption of Chapter 760, they would have done a much better job than these one sentence passing statements about discrimination. And they certainly did not adjudicate the 2017-2020 Chapter 760. I mean, we can argue. I mean, I've thought about this to the point that I've lost sleep. And we can argue about the policy reasons behind what Miami's doing and Orange County's doing. In Miami, they have given special protections to intersexuality, androgyny. You exhibit characteristics of both a man and a woman. They've given special protections where you can haul business owners in and lever them for money under the specter of litigating from 1 to 3 yards. If you're too tall, if you're too short, if you're too fat, if your culture or heritage is discriminated against and you don't speak proper English or you don't speak English, it's broken, you potentially have a cause of action. If I'm wrong on this, they can come back and do it. My point is that the primary edict of implied preemption, the first is it a pervasive code? No one would dispute that Title 44, Chapter 760, Part 1 through 5 is not extraordinarily pervasive and comprehensive. I can only think of maybe Chapter 499 that's more comprehensive. But the second part is there strong public policy reasons to invalidate the legislation? In here, in D'Agostino from the Florida Supreme Court, it says the court should look at the history of a statute. They should look at its evolution. They should look at its amendments. So that's what I did. It is absolutely mind-numbing that you can live in Miami or Dade County and you can be hauled into court the very next day after the alleged discrimination because you're too tall, you're androgynous, you're too short, you're too heavy. I mean, this idea we're going to create this world utopia, that's fine. We can all debate that, but that's the legislature's prerogative to determine whether or not we're going to create a utopia and whether or not we're going to create these special classifications. And that's why this judge deserves great kudos for stepping out there and making the decision, right or wrong.
Mr.
And their
Mason,
argument that it's
Mr.
been
Mason,
litigated.
let me ask you this. Is it your contention that local governments are absolutely prohibited from enacting these type of anti-discriminatory ordinances, or is it your position that they have authority to do that, but Orange County's is invalid for various reasons?
Both. Now, to be candid, I'm a working lawyer. I've been practicing roughly 31 years. I got one client, and it's strange bedfellows that we have a go-go bar is the vehicle by which these discrimination ordinances are being challenged. You could have never convinced me that this would be the case that came before the 5th DCA. But if my client wins on conflict, it's over for my client. My client is out of this case. It's dismissed. They have to go through the administrative process. It's very elaborate. It's 6 to 12 months in Tallahassee from the time you file it. There's lots of public policy reasons. You said that in Stacey McLean. The irony is Orange County just defended the case and got it kicked and won it, claiming that the mandatory provisions of Chapter 760 require dismissal. But in this case, they're claiming there's no conflict and that Chapter 760 is permissive and that there's no overlay or that controls local government's actions. No court has ever said that. Chapter 760 is not permissive. But do I think you should invalidate it on preemption? Absolutely. I think that what's occurring here, I mean, the public policy reasons behind this case is Exhibit 1. How many people have been forced to litigate in these cities and counties who are a minority? They claim they're a majority, but they're not. They're a minority of the constituency in the state of Florida. They're powerful, they're vocal, they're strident, but they're not the majority view in the state of Florida. And the idea that people have been hauled into court and forced to reach into their pocket and pay litigants money because they did not go through the administrative review process is Exhibit 1 to show the public policy reasons why they shouldn't be passing these things. Number 2,
Mr. Mason, you're referring to Stacey McLean case, that the firefighter who was discharged by or brought suit against Orange County. Did he bring a claim under the Orange County discrimination ordinance, or he brought a 760 claim, didn't he?
Exactly. He brought a 760 claim. But my point is they've made an argument. They made an argument that all of Chapter 760 is permissive. It's discretionary. They cited, their only thing they cited was an unpublished trial court decision from a judge in Tallahassee who said all of 760 is permissive. No one has to comply with it or follow it. You only have to follow it or comply with it if you file it under Chapter 760. but it has no power whatsoever in terms of comparison and contrast with city or county law. But what he did was he rewrote Article 8. I mean, going back 150 years in the state of Florida, cities and counties, even under the enabling legislation, they are subordinate to the state legislature. And I understand why Miami wants to create their own set of scripture down there of what's discrimination, what is not discrimination. And that's fine. Maybe reasonable people can differ upon that, but it's not their prerogative. They do not have the power to do it. They should be stopped. The Florida legislature agrees with that, then the Florida legislature will step up. And I'm asking the court to find that that's the preeminent, strong public policy reason for eliminating these ordinances in toto across the board. In terms of conflict, I don't mean to be condescending, but I think that, slam dunk is not a very good legal term of art. But if you look at this case, they've never litigated conflict. It's been token resistance. At the trial judge, they didn't litigate it. In the brief of Mr. Dietz for the appellant, he doesn't even address conflict. And he even redacts the order from the trial judge where he talks about the alternative grounds of conflict. And when he started off his oral argument today, his first word was, I want to talk about preemption. And then when the lawyer from Miami Beach gets up here, he hides behind a procedural argument that we have to file a lawsuit and interplead somebody. No one wants to address the merits of this thing. They should be forced to address the merits of this thing. It's a case of great consequence. And if I'm being too strident, I apologize. I mean, I was concerned about doing this digitally because I feel like it's robotic and we lose who we are as human beings, and so my original thought, I should try to be the stoic professor, but it's not my nature. It's not who I am to be the stoic professor. And I'm asking the court to affirm it on all grounds, both conflict and preemption.
All right, thank you, Mr. Mason. Mr. Dietz.
Your Honors, it's been the foundation of Florida and the police powers of the counties to protect their own citizens. It's a little bit strange on the day after the Supreme Court decided the Bostock versus Clayton County case, my client has the issue to talk about what values are. And in 1977, Miami-Dade had the values to allow all human beings, whether gay or straight, to have equal rights. And now it's the law of the country.
Counsel, let me ask you, how does an employer who has multiple locations, say McDonald's, for example, they've got locations in probably every city and county that is Amici in this case. And so what if Miami Beach decides that they're going to outlaw certain discrimination, but that same conduct is not outlawed in Orange County? How is that employer, what kind of policy does that give us if that employer doesn't have a consistent set of rules to apply across the state, whatever the rules are?
And Miami Beach actually did try to do that with its minimum wage ordinance. And the legislature told it, no, you can't. And the legislature said, you cannot do that, and they preempted it. The legislature is well known for regulating commerce between the counties. And in this specific matter and in this specific law, the legislature chose not to. And that's why we have 76007. And that's what that statute says. If the legislature wants to stand up and to say that you cannot legislate this, they've had opportunities since 1977, many times, and they have chosen not to. And in addition, Mr. Mason saying, the law changed, it hasn't. The 76010 switched to 76011 in 1992 when they added public accommodations. And again, even adding public accommodations provisions, the Florida legislature, who has this law and who has the power since time immemorial, could have said, we're going to change this. And throughout the 80s, and the 80s is not far back, the Supreme Court has said 3 times that, number one, counties have this power. Number two, they can exercise this power in light of the Florida Civil Rights Act, and also on top of that, in light of the Federal Civil Rights Act. What would happen if Florida decided now to say, you know what? Even though the court in Bostock said we can't discriminate against for sexual orientation, we're going to change our laws to do this. Then that would be a preemption, a conflict argument. But to the extent that they say sex, it's covered. The law in Laborers International
Mr. Gates, you need to wrap up in a sentence or two.
Okay, this is, Your Honor, your question involving the issue of motion to dismiss in jurisdiction. Briefly want to touch that. We have, the issue is the court's decision. They bought Mr. Mason's argument lock, stock, and barrel. They wanted to, he took the power away, the local power that legislatures want, that local county commissions want, and he made it clear in his order that was even non-final, that this was unconstitutional without even giving the county the chance to have a say, even though it was in the briefs. Accordingly, we believe that not only should this court decide that the county has the right, in fact, the law requires the county to be, in this case, in number 2, please, these 3 Supreme Court cases, these are the cases that bind this court, and the court should reverse what the circuit court stated.
All right, thank you all. We'll be in recess until our next oral argument at 11 o'clock. Thank you.
Thank you.
Your honors.